Okay, compensatory education awards. Okay, let's say you go through due process or mediation and you negotiate compensatory or remedial services for your child. That's number one. We're going to talk about that. How can it be used? What can it be used on? But at the same time, let's say outside of due process or mediation, that just in an IEP meeting, you come up with an agreement with the school that, hey, my child's owed X number of services because my child didn't receive these services, is not making the progress desired, and it's because you guys had a long-term aid in there and my child wasn't receiving the services. And that can happen outside of due process. That can happen outside of mediation. So in those situations, it folds into what I'm about to say. But mediation and a due process decision, those are both legally binding. Okay, there was a legal end to it, meaning that if the school violates those agreements, you can file in federal court to compel the school legally. Now, if you come up with this just in an IEP meeting, you would have to go through the steps of filing a due process complaint if the school falls into noncompliance and doesn't do those. Now, what's the difference? Just an extra step. Because if they fail to comply with what's written into, let's say, your amendment section as to what services they're going to provide during what period of time, because it needs to be written down, guys. They don't sit there and allow them to make a verbal promise of services. It needs to be on paper. It needs to be in an email. It needs to be explained in the IEP itself as to, what those services will look like, how they're to be provided, where they're to be provided, for how long they're to be provided, and what the purpose and goal that is to come from these extra hours. What are we set out to accomplish? It's no different than an IEP, guys. We have goals, we have services. So what is it that you're trying to accomplish? Using what approach, what methodological approach, how many hours in order to accomplish that goal? You got to have a purpose. You got to have a roadmap of what we're trying to accomplish. Okay, so keep that in mind. Now, for due process decisions or mediation decisions that are legally binding, guys, I'm a little confused by this because it says comp ed awards. What can and can it be used for? And guys, you can't have. I guess it can happen. I'm just trying to wrap my head around how in the hell it could happen. But you don't have a legally binding agreement or a decision by a hearing officer without having there be explicit instructions as to how the hell that compensatory time is going to be used and who can implement it. We don't leave open ends, okay? That's just not what good attorneys do. That's not what good hearing officers or judges do, all right? And that's not what good mediators do. If, let's say, you're representing yourself, you didn't use an attorney, but you went to mediation, or even you represented yourself at due process and won, you have trained mediators that know that you have to have explicit terms written out explaining the compensatory hours and what you're using them on, or what you can or where you can use, up to what amount, if it's a monetary amount, or if it's implemented by the school staff, for what purpose. All of that's got to be in there. It's got to be absolutely defined and not open-ended, because what you're trying to avoid in any kind of legal contract, and that's what a mediation agreement is, or a due process decision is, or a settlement agreement. Guys, it is a final document that is enforceable in law that you're constructing to explain exactly what something is and how it's to be used in order to correct a problem. And if you're not correcting the problem because you did not do a good job in constructing how that's to be, then all you're doing is wasting more money because, in time and people's energy, because you didn't solve a problem. You created a new one. But now the two parties are at odds with each other because they don't understand, what the interpretation is for the use of these services. The schools say, no, we're going to implement. And the parents' idea is that they can go out and find whoever they want to implement those, 200 hours of academic services. But I can tell you, if you have somebody that just wrote 200 hours of compensatory services, then I can tell you the default is that the school gets to implement. You don't get to sit there and go out and choose whoever you want. And the school pays for that. That isn't how this works. Because in most cases, this law is intended for the school, who is the funding agent. They get the special education funds from the federal government, from the state government, in order to implement this stuff, along with their local funds mixed in there. All right, so implementation is the legal duty of the school. So the presumption is that if you have something that's ill-defined and not defined well, then it would fall upon that legally obligated agency, which is your public school, to provide those things, unless you have terms that specify otherwise. And so we do settlement agreements and mediation agreements all the time, guys, and we absolutely define who can and cannot implement those extra remedial or compensatory services. You do not leave it open-ended. And for compensatory and remedial services, if they're provided over the summer, if they're provided after school, then guys, I also add in the parent mileage in order to take advantage of that, because these are owed services for your child, but yet you're supposed to dig in your pocket when this is a free, appropriate public education to sit there and transport your child back and forth. No, the school's obligated under a parent contract to reimburse your mileage to participate in these extra services that were owed you. The school should have provided them when they were supposed to during your child's IEP year. Okay? So that's the other thing that we add in there. It's not your fault, and so you have to sit there and think through all of the things that it's not as easy as you might think, but you have to define how and for what purpose and where, these services are going to be provided. And I'm telling you, if it hasn't been defined well enough, then the default of interpretation by any judge, depending on what the language says, but if it's that vague and then ambiguous as to you have a total number of compensatory hours and it doesn't say who is going to be implementing, the default is going to be the school is the one that is implementing, because they are the ones with the legal obligation. And if you sit there and you go, well, they're the ones that screwed up. Exactly. So they're the ones that presumptively have to clean up the mess and do it right, unless your agreement specifies otherwise. And we do that as well. But we also do things and define things to where the school has to raise the level of the services they're providing and provide it correctly. It all depends. So the devil's in the details, always. And when you're constructing an agreement, or before you put your pen and sign your name, which then it becomes binding, and in many of these situations, you can't change the language. Doesn't mean that I haven't seen what the mess is here, but sometimes you can go back and ask for another mediation to get clarification added into that. But mediation is a voluntary process. The school may say no. Doesn't mean you can't try. But the lesson learned here is be very specific and think through all of these problems in different contingencies so that you have all the bases covered for your child.